On January 28th, the Washington House Agriculture and Natural Resources Committee held a hearing on HB 2170, which would allow the Washington DNR to shut down more of Washington's public working forests known as state trust lands and instead sell carbon offsets and other ecosystem services. At the beginning of the hearing, Representative Ed Orcutt asks a DNR official if such a policy would impact sustainable timber harvests and the jobs that depend on them.
Chair, so the way the bill is written and the way you foresee it being implemented if it were passed like this, would there be any reduction in any way, shape, manner, or form of the allowable cut with the frequency of timber harvests or the amount of timber jobs that would be necessary to perform those timber harvests?
The harvest would be affected by that.
Under the state constitution and state laws as state trust lands, these public working forests are required to be managed for the benefit of defined beneficiaries, including schools, libraries, public safety agencies, and others. During the hearing, the committee heard concerns with how the bill would affect beneficiaries, communities, and the forest sector that depend on sustainable timber harvests from state trust lands.
Without clear guardrails, ecosystem service contracts could functionally reduce harvest levels on working forests, undermining mill supply, rural jobs, and timber revenues that fund schools, counties, fire services, and a host of other beneficiaries.
As written, HB 2170 further jeopardizes our economic stability and overlooks DNR's own reports showing that restricting sustainable harvest leads to 100% carbon leakage as production shifts to less regulated regions.
State trust lands are not abstract environmental assets. They are working lands that create great jobs, feed families, and they fund the local services that depend on those timber resources and revenues. This bill lets DNR convert working state trust lands, which are subject to fiduciary obligations, into long-term carbon contracts without an analysis of revenue impacts, consultation with beneficiaries, and without a local impact analysis.
Revenue generated from ecosystem leases would be a small fraction of the revenue earned from timber harvest, which would be contrary to the legislature's obligation to the trust beneficiaries.
These public working forests generate revenue for counties, school districts, fire districts, ports, hospitals, and other local services providers where your families live. Each logging site we have is an investment of several millions of dollars of equipment. Those purchases of equipment benefit other companies in this state. Why not harvest timber where we know where it comes from instead of from countries where we don't know how they harvest and their environmental standards aren't up to the care that we take? We produce sustainable carbon-storing wood products, and our work reduces the reliance on imported materials and lowers Washington's carbon footprint. By allowing DNR to remove additional timber, potentially for 125-year contracts, you are hitting the small rural towns and counties that have already been hit hard.
That for each million board feet of timber harvested, this supported 15 direct and 36 total jobs. Again, a reminder how important the DNR timber sale program is to the industry. For these reasons, we ask you not to move this bill forward.
In present, trust land revenues have helped us maintain and improve school facilities that support student learning and safety. Just a couple of years, those dollars saved 2 teaching positions during a difficult budget cycle. Washington State trust lands are managed to generate ongoing revenue for public schools and other junior taxing districts. Rural counties like Clallam County rely more heavily on these revenues, so reductions hit our schools harder than in larger urban areas. For small school districts like ours, these are not optional dollars. They enable us to maintain healthy, safe school environments where students can learn and staff are able to provide quality instruction.
Mason County has long been tied to the sustainable harvest of timber, not only as an economic driver, but as a way of life. Generations of Mason County residents have benefited from our working forests and continue to rely on them to support their families and critical public services like education and fire protection. Further limiting access to timber at a time when the state and DNR is facing serious budget issues and local jurisdictions face similar budget challenges is a sure way to make matters worse, and further restricting logging and the economic activity that comes with it.
This legislation is potentially setting the legislature up with a false choice because as the report made clear, these markets are not mature. They're highly volatile. The DNR does not yet have the internal expertise that's necessary to really execute in these new lines of business. And the report did not account for the mill infrastructure and other community infrastructure that's really necessary to support an ongoing timber
Skamania
harvest.
County, more than 80% of its land is publicly owned. Less than 2% is taxable at full market value. It makes it pretty hard to make a county budget work. For decades, sustainable timber harvests have been how they fund their schools, roads, their public safety, search and rescue, and all of those essential services. But as harvests have declined due to regulatory encumbrances, the county has lost both timber revenue and the broader economic stability that comes from it. 2170 would make this worse. Even you've heard from DNR say these markets just are pennies on the dollar compared to what we get from our sustainable timber harvests. But still somehow, if we found a way for them to work and bring some money to the county, we might lose our mills anyway. And those mills will lose the people who are spending money in the community on goods and services and really making the economic ecosystem of the Columbia River Gorge work. Now, we've been here before. With the owl in the 90s, these timber communities were promised economic transition and workforce development, and those promises didn't come through. So when we talk about the word trust in this sense, we're talking about it in two senses. And it can be hard to trust that we won't lose more revenue with good proposals, even with great proposals. The trust has been broken. We're still looking for the investments that can bring Skamania up to what it used to be, where its schools had the resources that they need. That is one of the reasons, and there are many more in the written comments that I hope you have time to look at, why we are asking you not to advance this bill. Thank you.
Also during the hearing, there was a discussion about CNW v. Franz, a 2022 state Supreme Court decision that unanimously reaffirmed the DNR's fiduciary obligation to manage state trust lands for beneficiaries. Anti-forestry groups, and now the DNR, has spun the decision, suggesting it relieve the agency from this obligation.
This morning, we've heard reference to the Conservation Northwest lawsuit on the 2 or 3 occasions here, and you and I have had conversations in the past around this. But what I've heard this morning, I'm a little confused about maybe the results of where that has ended up. Could you maybe help me understand that a little better?
Yeah, thank you, Representative, for that question. I'm not surprised that there's some confusion. I was pretty disappointed, frankly, to hear the position of the department on the interpretation of that case. I think that some things really need to be clarified. First of all, it's important to know the case was dismissed by the trial court, and the decision by the Supreme Court was to uphold that dismissal. So the arguments that were being made by Conservation Northwest were dismissed in that case. The Skamania decision that talks about the fiduciary responsibility being undivided loyalty to the beneficiary was not in any way, shape, or form overturned by Conservation Northwest versus the Department of Natural Resources. So there was no overturning of that and no obligation, and there was no finding of a dual fiduciary responsibility. What the court said was there's no obligation by the Department of Natural Resources to necessarily manage these lands for maximum revenue. But that was something we already knew, right? We've already agreed to the HCP. The courts have already said in the past that if there's a way to manage those lands to meet their fiduciary responsibilities that also provide dual benefits to the public, they're free to do so. That was something that was already available to the department. That was nothing new in this particular message. We already know there's a general obligation to generations moving forward, so of course we manage the lands in a sustainable way that doesn't necessarily maximize revenue. It's really important not to be fooled by misinterpretation of this particular case. There's no dual fiduciary responsibility that was somehow found in Conservation Northwest versus the Department of Natural Resources. The fiduciary responsibility remains as undivided loyalty to the beneficiaries.
But today we're in kind of an alternate universe where an 8-0 decision by the Supreme Court in Conservation Northwest Franz is spun as striking down the fiduciary duties that are in place when it in fact reaffirmed those. So I want to thank you and encourage you to continue to lean into your role as trustees, as financial advisors. Would you really grant DNR authority to divest from a proven investment that benefits the trusts, the state, and Washington communities for one that would harm them all with no analysis and environmental benefit? Thank you.